just want to welcome you to our presentation today regarding planning for a diagnosis of dementia and things to think about both legally and financially. I'm attorney Kathleen Summers here with Generations Law Group, and I am pleased that John Bicknell, a certified financial planner, has joined us today to talk about this issue. And thank you all for joining. John, do you want to just give everyone a little bit of background about yourself?
Sure. So I'm John Bicknell. I'm a certified financial planner, Boston local, grew up in Andover, Massachusetts, big skier, so like to ski almost here. It's, I know, probably getting some booze from the audience already, keep it warm, guys, right? I like the skiing. I help clients really right at retirement. My specialty is helping them just create a paycheck from their wealth during retirement. And so also help them with their complex needs. So in integrating taxes, investments, and estate planning.
Wonderful. Thank you. And again, John, thank you so much for joining us today. And I'm for those who don't know me, I am attorney Kathleen Summers. I'm one of the founding partners of Generations Law Group. I really specialize in estate planning and crises planning for those who may be dealing with a loved one who is facing an illness or some type of diagnosis. Today, as I had said, we're really going to be talking about the financial and legal planning aspects of planning for someone who has a diagnosis of dementia. And one of the places I really want to encourage people to start is neither legal or financial, but it's really taking time to understand the diagnosis that you or a loved one may be facing, to make sure that you have thorough medical evaluation regarding that diagnosis, and that you really do understand as much as possible the type of dementia that someone may be dealing with. Because a lot of this is going to play into the course of the illness, what kind of to expect as time goes on, and will help to really kind of guide the type of planning that might be necessary for you and your loved one and your family. The other thing is to get annual evaluations about where someone's at, because things do change fairly quickly, and to be working with a provider who is really knowledgeable about your loved one's type of dementia diagnosis, because things are changing in this arena constantly. I had just seen a report on the Today Show yesterday about some big breakthroughs that are starting to happen in the world of Alzheimer's. And so you really want to make sure that whoever you're working with from a medical standpoint is staying up to date in terms of the multiple changes that are happening continually in this environment. The other thing I like to encourage people to do is to really reach out to their support systems and to start to get to know as early as possible what type of resources are out there. And a couple of places to begin is to reach out to your council on aging, to be able to speak with them about what kinds of resources may be available in your town, your community. Reach out to your local, what we call ASAP. This is a senior access point. And in Massachusetts, I believe there's either 26, 28 senior access points that serve a catchment of towns within their area. In our immediate area, we tend to work a lot with Minuteman Senior Services and Bay Path Senior Services. They are both the designated ASAPs, and they are really put there to serve seniors and those with disabilities within their catchment areas. They will have a lot of resources for you to be able to avail yourself of. And then to reach out to some of the specific disease associations, such as the Alzheimer's Association. Again, they have a tremendous amount of information to help guide caregivers, to guide individuals who are dealing with a diagnosis of Alzheimer's, to help lead you to things to think about as someone's disease progresses. So really get to know what your resources are out in your community as early as you can, because the last thing that you want to be is in the middle of a crisis and starting then to try to find out where you can find some help. Get to know your resources that are out there as early as you can so that you're able to reach out to them and use them effectively. So the next place that you really want to kind of look at in terms of this is understanding your health insurance and to understand, again, early as possible, what types of health insurance that you or your loved one is covered by. For instance, a lot of people oftentimes mix up Medicaid and Medicare. And just quickly to understand, Medicare is usually the one that most individuals over the age of 65 are under. This is a federally run program and it's based on age or disability. So again, most of us over the age of 65 are able to avail ourselves of the Medicare program. Medicare is what I like to consider to be a sick insurance, meaning that it is not there for your standard health, your health kind of keeping health up benefits. If we think about our employer plans that we may have come from before going on Medicare, a lot of employer plans cover well visits and may cover things like even health clubs and have a kind of a cachet of benefits that are more geared toward maintaining health. Unfortunately, our Medicare system is more that is reactionary to illness, and it is really there to cover occurrences of illness, to cover hospitalizations, and even those are oftentimes not covered at 100%. There are some Medicare programs that you can buy into that are more like the old employer plan that you may have been on at one point that does have the wellness component to it, but you do need to pay extra for that plan. Medicaid is the state-run system. Now, it does have a federal component to it, but it is administered by the state. And here in Massachusetts, it's called Mass Health. Medicaid is typically for people who meet either certain income eligibility standards or asset eligibility standards. And we have two basic forms of Medicaid. One is community-based Medicaid, and that is for someone who is living in the community and who needs additional services. Those services will be based oftentimes on income. And we have long-term care Medicaid. That's what we oftentimes view as nursing home level Medicaid. And that really is going to be based on asset holdings in terms of eligibility. And then people also do have private insurance. And sometimes that's either private insurance, again, through like an employer, or it may be a supplemental plan that you have purchased. And understanding what your healthcare will and will not cover is critical. And understanding what the healthcare coverage is for your loved one who's dealing with dementia is absolutely critical as you move forward with planning. So let's talk a little bit about why to plan and why planning is so important. And oftentimes we'll have people who come to see us and say, well, my loved one had a diagnosis of dementia, so they're not able to do planning. And that's not always true. The diagnosis of dementia itself, and regardless of the type of dementia, is not really the determining factor as to whether someone can participate in planning. It's really going to be how far along they are in terms of their course of illness, whether they still have the capacity to be able to understand legal documents and to be able to make decisions for themselves. And so that is something you definitely want to explore with a professional before making the determination that someone can't participate in planning. But of course, the earlier we do the planning to when someone has received a diagnosis, the better it is, because we oftentimes have a much larger scope of planning that we can do with that person. And so why do they want to plan, or why do you want to plan if you have a diagnosis of dementia? One is to be able to maintain control for as long as possible. And I'll talk about that in terms of some of the legal documents that we recommend. but we really want that individual's wishes to be followed and to be having them stay in as much control as possible for as long as possible. The other thing that planning does is when someone is no longer able to maintain the control, so they're now relying on others to be making decisions for them, by planning ahead, they've identified the people they want to be in those important decision-making positions, and they've been able to provide them hopefully with a framework for how those decisions should be made. So planning ahead is critical in order to help support and maintain control for as long as possible. Another reason for planning ahead is there may be an opportunity for us to protect assets. Now, this becomes a little bit more difficult when we're dealing with an individual, but it's always worth exploring whether there are some things that we can do when we're talking about an individual dealing with the diagnosis of dementia. But when we are dealing with particularly a married couple, there's oftentimes a lot we can do. And we're going to get into a little bit later in the presentation. John's going to really be able to show us how pre-planning or even planning kind of in what we call the 11th hour can be extremely helpful when we're dealing with a couple to help maintain assets, particularly for the one who's going to stay living in the community, the quote unquote healthier of the two. So allowing us to have as much lead time as possible is critical. And so planning as soon as possible, as early as possible in the diagnosis, the course of a person's illness is critical. And we really want to avoid, if we can, guardianships and conservatorships. These are court actions that we have to take if someone has failed to plan and does not have decision makers appointed. Should they lose their capacity to be able to handle their own affairs and someone is not in place, then we have to turn to legal proceedings of guardianship and conservatorship to be able to get decision makers named. This is a costly process. It is one that is not a private process because it is court proceedings, and there ends up being court oversight into all the decisions that are often made by the guardian or the conservator. That's both costly, expensive, and really does lead to a lack of privacy. So we want to avoid that whenever we can. So let me start by just kind of talking about what is basic planning, basic and essential estate planning that we think everybody should have in place, and particularly if there's a diagnosis of dementia. So most people know first about a last will and testament. Last will and testament is when we're providing instructions to the world about what we want to have happen with the assets that we may own when we pass away. This allows a person to be able to really give clear instructions as to how things should be divided after someone leaves, after someone passes, who should get what, how things should be left. It also allows us to appoint who should be managing that process, the personal representative. When we have a married couple and we have an individual who has a diagnosis of dementia, when we're looking to do this pre-planning, we may look to do a very special type of last will and testament for the healthier spouse. Oftentimes our planning involves the renaming or retitling of assets between the couple, in which we're looking to take steps to impoverish the ill spouse and give everything in real time to the healthier spouse. But none of us has a crystal ball to know if the healthy spouse were to pass away first. We want to make sure that their last will and testament doesn't undo all of the planning that we've just done by leaving all assets to the sick spouse. So there's a special way of writing that last will and testament to include what we call a testamentary trust. This is a specific type of trust that is only created upon the death of the healthier spouse to provide for the needs of the sick spouse without causing those assets to be part of an eligibility review for things like Medicaid or mass health benefits, or to be reachable by the state. So it allows us to be able to protect those assets to ensure they're there for the benefit of the ill spouse, should the healthy spouse die first, but not being attachable or counted against the individual for eligibility for state benefits. So that's a critical piece we need to make sure is in someone's last will and testament. The rest of the documents I'm going to talk about help to manage things while someone is still alive. And so these documents become critical. If we can get these documents in place for the individual who is dealing with the dementia diagnosis, we want to do so because, again, it leads to those things I talked about earlier, making sure that their wishes are known, making sure that they are maintaining control for as long as possible, and that they've been able to identify who they want to step into their shoes should they not be able to handle their own affairs. So the first one is a durable power of attorney. This is a financial tool for the most part. It is a document that's very broad-based that allows an individual to name someone else who will step into their shoes to manage all decision-making except for healthcare. And so again, it is very broad because we don't know the types of things that the attorney, in fact, that's what we call the agent under the power of attorney, will have to deal with should they have to step into their loved one's shoes. And so a durable power of attorney allows you to name the person of your choice who'll step in to manage your decision-making for you, should you not be able to handle those decisions because of competence or incapacity in the future. Very critical document. If we don't have it in place and someone no longer has the competency to make decisions for themselves, then we have to go to a court and turn to a guardianship proceeding. The next documents are all healthcare related documents. So like the power of attorney, a healthcare proxy allows you to name someone to step into your shoes to manage your healthcare decision-making should you become incompetent or incapacitated. So this is a document in which you name somebody who's going to step into your shoes and make a broad range of healthcare decisions for you should you not be able to make them for yourself. It oftentimes is used for things like end-of-life decision-making. And so it's critical that you have somebody identified in the document who's going to act as if they are stepping into your shoes and doing what you would want to have done should that healthcare decision-making need to be taken over. A critical document to have in place, because without it, we have to go to a court and we have to have a guardian appointed. And again, we want to avoid court involvement wherever we can. Having you control who's going to be your healthcare proxy is a critical piece to put in place. The other thing to know under healthcare proxies is that oftentimes the authority that is given under the document is much broader than the authority that a court would give under a guardianship. So let me explain that. If you're named as the healthcare proxy for someone, and there's the need to use something like antipsychotic medications, the healthcare proxy usually gives the authority to be able to make decisions around the use of the antipsychotic medication, or to admit someone to something like a skilled nursing facility. When we have a guardian appointed, and there's questions about whether someone should be administered antipsychotic medications, or there's a question about whether they should be transferred and admitted to a skilled nursing facility, the guardian has to involve the courts every time they need to make these decisions. Where when a healthcare proxy is in place, no court involvement is needed. and we don't have to involve additional people in the decision. We don't have to have a court overseeing the decisions that are being made and ratifying those decisions. So having, again, the healthcare proxy in place ahead of time really gives a much broader scope of authority and an ability to be able to act without involving any kind of court action. And then the last healthcare document is the HIPAA authorization and release form. And this is a document in which you name people who you are comfortable having your healthcare providers share sensitive healthcare information with, to have the conversation, to be part of the discussion about your healthcare and the decisions that may be made. Now, remember, the people in the HIPAA document are not necessarily the decision makers. We certainly would give your healthcare proxy the ability to be to get information about your healthcare needs, but you may want to include a broader range of people. For instance, you may have your spouse named as your decision maker, but under your under your healthcare proxy, but you may give permission, let's say, for your children or a sibling of yours or a very good friend to also be part of the conversation. And so the HIPAA allows you to name those people who you are comfortable speaking with your healthcare providers about your healthcare situation. So now we're going to jump a little bit into the financial part of it. And I want to begin first by kind of setting the tone. Most times when people come to see us, it's about planning for becoming eligible for something like Mass Health to help pay for long-term care costs. As John is going to illustrate in a few minutes, the cost of healthcare is extreme. And when you're particularly taking care of someone and having them have to receive their care in a long-term care facility like a nursing home, the cost here in Massachusetts is anywhere between about $12,000 and $17,000 a month. So that's a very, very costly alternative. If we're able to do some planning ahead of time and get someone on Medicaid, or again, what we call Mass Health, then that can be a tremendous savings for someone, or for a couple in particular, when they're dealing with one of them needing this type of care. There are some rules that we have to pay attention to, and this is just really kind of a quick overview of Medicaid planning. But some of the things that you need to know is that the person who we are trying to get the benefit for can have no more than $2,000 in assets in his or her own name. And when there is a spouse, the spouse who's deemed to be the community spouse can have no more than approximately $130,000 in his or her own name in assets. And when we're talking about asset holdings, we're talking about the full scope of holdings: savings plans, investment accounts, retirement accounts, real estate that you may own, other than the primary home, and I'll explain that in a moment. But if you own other real estate, the value of life insurance policies that you may have, if there's a cash value or a face value of those policies, they may be countable toward that $130,000 asset limit. When we're talking about the primary home, and again, it is only the primary home, it is not any investment real estate, rental real estate that you may own. The state does allow you to continue to own a primary home. And when there's a married couple, we oftentimes look to move that to the community spouse alone. And as long as the equity value in that primary home is less than $906,000 at this point, then it is not counted as an asset. And so that's critical. There's oftentimes a belief out there that you're going to have to sell your home. And there are things that we might be able to do to protect that home. And in this case, if there are spouses, we can transfer between the two spouses without incurring any kind of penalty. And that's where the 5-year look back comes in. Oftentimes when we're doing planning, people have heard about this 5-year look back. And really what it is the state says that if you've given away assets, meaning you've given them to other people or you've set up some kind of irrevocable trust situation, within the 5-year period of time before you apply for assistance from the state, then it may cause you a penalty period and may cause you to no longer be eligible for assistance under the Medicaid program. So the 5-year look back is always critical when we're looking to transfer assets. But one thing to remember when we're transferring between spouses, the 5-year look back does not come into play. So that's really important to know, and why we can oftentimes do planning even after someone has received a diagnosis. So want to just talk quickly about some of the things that when you're dealing with your insurance, and John's going to talk and go through the scenarios that show us the financial piece, but we talked about health insurance and understanding what your insurance covers and doesn't cover and how critical that is. Oftentimes people think that if they're on Medicare, remember that's the federally based program, that's going to cover their nursing home stay. And the truth of the matter is it does not. It will cover, in some instances, the rehab portion of a nursing home stay. So if someone, let's say, has fallen and broken a bone, gone into a hospital for care, and then are transferred to a nursing home facility for rehab services, those rehab services are often covered by Medicare. But there are rules around what amount of coverage they will provide. First of all, there needs to be at least 3 nights of a stay in a hospital. And so it's critical to understand that what type of hospitalization someone has had. We have actually found that people believe they've been admitted to a hospital for care, and then later find out that they were never actually admitted, but they were on what we call an observational status. So that's really important to know, has somebody actually had 3 nights of a hospital stay? And then you need to know that the Medicare benefit does have limits. It's 100 days of rehab benefit that someone will receive. And the first 1 through 20 days is usually covered at 100%. And 21 to 100 days is usually covered at 80%. And so the other 20% is either private pay or under another insurance if there is a secondary insurance there. When someone is entering a nursing home from their home, so they have been at home receiving care at home and have gotten to the point where they're no longer safe at home, or they no longer can have the care level that they need provided for at home. When they enter a nursing home, then we're looking at a very different situation in terms of coverage. They're either private paying for that care, or if they had long-term care insurance in place, the long-term care insurance will help to pay for that, or they're becoming eligible for Medicaid. And that's the planning that we talk about in order to get Mass Health. So John, I don't know if you want to jump in here and kind of talk about some scenarios that we went through in dealing with a couple's financial situation.
Yeah, no, I'd love to. So great information. I think if I was thinking about a few things back from a few slides ago, just from a financial perspective on my side of the ledger, which is, financial, we're dealing with clients' accounts, and, obviously they have to be competent in order to do business with us. And so, a thing about the durable power of attorney is, for us, I checked in with the home office. We've had a couple instances, but none recently. You really have to have an up-to-date one, or at least our firm is going to ask for an affidavit that's going to just put really the onus back onto you, the person signing, that, this is valid. So that's good to hear, because I have heard horror stories of, I guess, powers of attorney that just weren't honored, even though they say in writing, hey, listen, the legalese says, these are never to expire. So
Absolutely, John. We see that too. And the other thing we see is sometimes powers of attorney require being activated. It says that we call them springing powers of attorney, that they don't become effective until a healthcare provider has actually stated the person is no longer competent. And we have instances in which sometimes the power of attorney requires two healthcare providers, two doctors to make that declaration. And I can't tell you how hard it is to get those things actually activated.
Right. And in time for, really the client to have, income that's needed to, maybe pay for the nursing home or pay for the care that they need. So, yeah, so I guess that was just one of the things from my perspective. But what you see on the screen here is, as it says, a married couple age 75, and everything's working. And we do a very specific type of planning that looks at every 5-year period for a client. And this is a graph of a typical client with some Social Security in yellow, and they pay some taxes, which are blue, and they take some systematic withdrawals from their investment portfolio, that's in green. And, again, we help them figure out how much that is and whether they can, see no red in this graph, it's what's happening here. And, this is a fairly well-to-do client. It's $1.5 million client that has about $4,000 in Social Security and needs $8,000 a month for their expenses. We assumed that they had about half of their money in IRAs and half of their money jointly held. And so that was really just the facts that we decided to use here. And so, hey, listen, everything is going hunky-dory. They need about, 20% of their money typically in every 5-year period moving forward. That's what's actually on the top, which is the segmentation, which again, I think is helpful for people to understand, because then, they can help or they can know how they need to invest their money, because, even this married couple age 75, it's a long time that they could still be, needing income. So maybe to the next slide, when something happens, and I've had it happen a lot. I've had it happen. I just was referred by our Medfield Council on Aging to a person who his wife is now in a nursing home and has a dementia diagnosis and is in full, care now down on the Cape. And so, it's easily $10,000 a month. And so, I think that's a small amount. Sometimes we've seen higher. I had a client just recently that ran out the entire amount of their wealth, and it took them a good 10 years or so, but it did end up running out, and that's a challenge. This is a married couple, and so what we are concerned with is the red there that you see in the graph, which is when the liquid assets now are gone, whereas a client before had that $1.5 million we assumed, and things were going well. And here we are with $10,000 a month or $120,000 a year for 3 years. And that's, what you get here. You get something that looks like this one. Yeah. So concerns, right? Yeah. So maybe it's time to talk about planning, because everybody knows, hey, listen, this is a significant event that absolutely can just decimate a financial plan. So what I did was I asked Kathleen, what do you do? So maybe Kathleen, let's talk about what the assumptions were here. The first one, I think, was, or tell us about planning and how might it work?
Absolutely. So this is a planning structure. And again, and I'm going to go back to the slide before. This is, again, John, and correct me if I'm wrong, when there's no ability to plan, that what happens very quickly, and you had talked about the red area here and how you can show the expenditure of money and how quickly that occurs.
Yeah. Yeah.
When we have a married couple and one is dealing with a diagnosis or an illness that we believe may lead to the need for something like nursing home care, there is a lot we can do even in the 11th hour to help to protect assets. And basically what that looks like is that we liquidate the assets of the ill spouse, so the one who's going to need the care, because To get them on any kind of state assistance, we have to bring their asset level down to no more than $2,000. Remember, we can't just give away assets. We aren't able to do that. We can't give them away to the kids or set up some kind of an irrevocable trust without incurring the 5-year look back. And if we believe that this individual is going to most likely need additional care within that 5 years, what we can do is change the holdings of assets from the couple, either jointly or in the hands of the ill spouse, and move it all to the healthy spouse. So we retitle the house, we retitle any kind of investment accounts they may have, savings accounts, checking. One of the big disruptions that we end up dealing with, and John, maybe you can talk a little bit more about this, is when someone has a retirement plan, because remember, their retirement savings are also part of their asset holdings for mass health eligibility. We have to liquidate the sick spouse's IRA retirement plan because we can't just transfer that over to the healthy spouse.
Yeah. And so when we were talking, about this case, I was interested in finding out what the graphs would look like. She was interested in the legalese oftentimes. And so as I hear you, what we would need to do is make sure that the healthy spouse has all the assets. And as you said, the IRA is only able to be titled in one person's name. And in this case, we assume that the husband here had 500,000 of the IRA and the wife had 250. And so we could leave hers alone because it's on her side of the ledger. But in order for us to get the $500,000 to her, it has to come out of the IRA. It simply has to pay the taxes that it's due, and that's pictured here as $175,000. It's, a lot of that IRA would get eaten up. And so, what I was looking to at least show a model on, and, financial models, like everything we talk about, including legalese, is dependent on the situation. So, this might not be a perfect representation, but it's closer than throwing darts. And so what I did was say, hey, listen, what else would happen? Not only are we going to lose this money in wealth, but Kathleen told me that, hey, listen, the healthy spouse can only keep $2,500 in income. So if you go back one slide and you look closely in years 10 through 13, just after that second bar, and then you flick it again, and you'll see we lost about $1,500 $1,500 of Social Security. So in years 11, 12, and 13, if you flick it back once, you'll see yellow show up in years 11, 12, and 13, showing $4,000 of income. Flick it back again and look where that is, and you can see it skips over a little to the right because they're not lined up exactly. But you see that now we're only getting $2,500 of Social Security.
Right.
Sounds like the institution is taking the $1,500.
So what happens is, just for a little clarification, when someone goes on mass health and they being the person who needs to go into the nursing home, their income is paid over in what we call the patient pay amount to the nursing home each month. So the person will continue to get their income just like they do now, but then each month they're allowed to deduct out expenses for health insurance. So their Medicare premium will come out. Any additional health insurances that they may have will also be deducted. And they're allowed to keep a whopping $72.80 of that each month for their own needs. And then the remainder amount of their income will go to the nursing home as the patient pay amount. So I think in this case, we picked on the husband and we said he's the one who needed to have nursing home care. And so his income is no longer coming in for use by the healthy spouse. It ends up having to go to the nursing home each month as the patient pay amount. Now, what John was talking about with the $2,500 limit is that The healthy spouse, if they have more than $2,500 a month in income, they can keep their own income. But if they have less than $2,500 a month in income, then they can make an argument that they should be able to keep some of their ill spouse's income to bring them to the $2,500 limit or to the level. And so that's why we use that as an assumption that the healthy spouse would be able to keep 2,500. But that's quite a big difference between what they had been receiving when both the healthy and the ill spouse were living at home, and we had the assumption of the $4,000 a month in income.
Yeah.
So planning, while we can do it, doesn't always look pretty. There are some real downsides to any kind of planning like this. As John discussed, we have to go ahead and liquidate the ill spouse's retirement plan in most cases and pay the taxes that are associated with that. We may have to annuitize the healthy spouse's retirement plan if it's more than if it is a part of the asset holdings of the 130,000 that he or she's allowed to keep. If it's more than that, then we have to change how that plan is being handled and how it's being held. And if they have assets that are above the $130,000, we have to purchase what is called a Medicaid compliant annuity with that additional money. And now we have to make it so that it's no longer an asset holding of the healthy spouse, but now it is an annuity that is providing them with a return of principal and income each month in order to be able to get the sick spouse on some kind of benefit.
And those could also be, I was thinking, an annuity oftentimes won't have the growth that maybe a stock bond portfolio. So there might be additional sort of, we'll call it losses for doing planning. But and one more note about the graph that you're looking at in front of you, if you were writing a few things down about the bottom of the chart here, the first two showed the client spending $8,000 a month. So I actually adjusted it so that there really wouldn't be much money left, but they would still have money. So they did need to take their income or their expenses down to $7,300 a month, do their planning, and still would be able to live at that lifestyle, slightly smaller than they were used to, but available for the rest of their life.
Right, exactly. One thing we didn't touch on, John, and I know you and I discussed it, but we really haven't modeled here because the intent of this program was really talking about someone who is dealing with a recent diagnosis of dementia and what kinds of planning could still be done. But long-term care, certainly, if someone has had the foresight beforehand to be able to put that in play. Or sometimes, John, we even talked about the healthy spouse may still want to look at the purchase of long-term care for themselves. And the impact can be, from a positive standpoint, it can really help in this scenario to defray costs, correct?
Oh, absolutely. I mean, if we're thinking about even covering half of what was in slide 2, say they had a $5,000 a month plan, that's certainly gonna allow for longer, or the red to come into the graph a little bit, later in the life. And so, some is better than none, obviously. And then because the planning is much easier, Kathleen, with two people, having knowledge that one person needed it and there might be another spouse that would need it in the future, you could apply for long-term care at that point. Typically, we're talking about in this example, the client hits the nursing home at age 85. You really can't get long-term care insurance at that point. But so this is a way earlier the better kind of thing. It's the actuaries know how to make money, and it's not by giving out long-term care like candy to 80-year-olds. It's just it's not their thing. They like to build the big buildings downtown Boston and reap profits. And as I say that, I realize the billions of dollars that was lost by MetLife, John Hancock, all these other carriers over the years, to the point where, they've actually dried up our shelf of opportunity for our clients.
Right.
MetLife does not sell long-term care insurance. They got whipped so hard that they do not sell it. John Hancock sells it, but in a very different form. The people that have had long-term care policies for a long time, they're lucky, even if they get those notes in the mail that say, hey, your premium just went up 40%. Well, believe it or not, it's because they underpriced it by 150%. So, you probably would want to pay it, even though it's difficult to swallow at that point. So I get it. It's no fun to buy in the first place. It's no fun to get a premium increase. But it is the one thing that really can upset a financial plan in retirement.
Right. Absolutely. Absolutely. So really, I think as a kind of ending, to just remind people that a diagnosis, there are things that if you are dealing with it or you're dealing with a loved one with a diagnosis, you want to gather as much information medically about that diagnosis as you can. Really find out what types of benefits are available in your community and get to know those benefits sooner than later. So you're not just trying to access them in the middle of a crisis, but you have a good idea of what's out there. And that planning may still be possible. And don't make the presumption that planning is now done. There may be some things that we can do, and you want to start looking at that as early as you can and taking a look at the impact financially and what you might be able to do in order to be able to preserve assets and keep, particularly if you're dealing with a couple, the healthy spouse in the community, while making sure there's quality of care, quality of life, quality of choice for the ill spouse. Well, fantastic, John. Thank you so much again for joining us today. To everyone who came on to the webinar, we really appreciate it. And we hope that was helpful. If you do have questions, always feel free to reach out to us.
Thanks for having me. That was great.
Wonderful.
Yeah.
Thank you, everybody. Be well.